are you listening to? Straight Talk with Kim and Carolyn.
I was informed by our Greencoats, we've got a full gallery of guests, and we're glad to have guests here anytime they come. Just want to make a couple quick reminders. We do this occasionally. As awesome as we are, we don't want you to cheer for us if we do something good. If we do something you don't like, the rules also state, please don't boo. We also have another rule that you can't use signs or any kind of visual signage demonstrating support or opposition to a bill. So I just asked the Greencoats to make sure that we are not wearing or showing any signage relative to any piece of legislation up in the gallery. If you've got those and want to use those, you're welcome to use those out in the Capitol.
Welcome to Straight Talk with Kim and Carolyn. Oh my gosh, we have headlines that someone was taken out of a committee meeting this week.
And it wasn't one of the usual suspects.
Not one of the usual suspects. Yeah. But it's, we had a problem with a man that he had a very, very offensive grouping of words on his T-shirt. And I guess that the chair took exception to it, and it was so disruptive. Do you know what it was that said?
Well, I will say, it said "we the people," but I will say I've heard differing reports, right? As to whether it was the shirt or whether it was the sticker. And so...
Well, the sticker is probably more offensive than the shirt.
Yeah, support HB60.
Right, yeah.
Yeah,
so,
okay.
Well, so we're not going to try that case so much because it's fresh, it's under investigation. But, we had an incident this week where someone was forcibly removed from a committee, allegedly in handcuffs, allegedly because of what a shirt or a sticker said. And that was right on the heels of the Speaker of the House also declaring... his own interpretation of free speech law. And so we have an amazing topic that we're going to talk about tonight with an amazing guest. We have with us from CATO Institute, we've got Thomas Berry. Thomas is a research fellow at CATO with the Robert A. Levy Center for Constitutional Studies and is the managing editor of CATO Supreme Court Review and Stanford Law graduate. And it has been featured in Federalist Society Review, National Law Journal, Wall Street Journal. So we have one of the top experts in the country really on free speech in the public forum. And so welcome, Thomas.
Well, thank you so much for having me. That was a very generous introduction.
Well, you bet. And we do have some very, very prominent events that have happened in the state of Utah during our legislative session. We have one day left. And all of a sudden, our Speaker of the House announced from the dais, and we have, just so you know, we have a gallery that sits above the floor. And it's very hard for most of the people in that gallery to see down to the floor. I know as I served on the floor, I really couldn't see anybody up there except for a few, which I think is a key point for this discussion as well. Yeah. But he announced that, and the first time really I've ever heard this announcement.
Yes.
But that he had announced that there would be no signs, placards, or displays of any political speech, expression, and that if you had a sign or if you were wearing signage, that you needed to either discard it somehow or excuse yourself from the room. And to my knowledge, in 6 years serving in the legislature and being an observer up in that gallery for many years before that, I've never heard that. And it was very concerning to me, but just a few minutes even before that, I went to go sit in the gallery, and there was a cluster of people who were not being let in, and I thought, what's going on? Well, we have these volunteers. They're typically retired volunteers that come in. And so Speaker Wilson announced that he sent these volunteers to go up and man the doors and make sure no speech entered, no displays of speech entered the gallery. So we really had people who were denied access, who were ordered, for lack of a better word, to remove any displays of anything that was affixed to their attire.
Yeah, and let's be clear, this was stickers. Signs, I do think, are a different thing. They can be disruptive.
Right.
To people around and behind
and
you.
they can be discarded.
Yes.
Okay,
But
so
these were stickers. And the gallery was actually, you ended up on the floor. I was in the gallery. The gallery was actually full of people with stickers before the announcement was made. And UHP, the Utah Highway Patrol, was sent around to have everybody take off their stickers. Again, that could not even be seen by most of the legislators on the floor.
So I do think that was fairly unprecedented in my experience. And so what are your thoughts on that? We sent you the tape. I don't know if you were able to hear that announcement straight from the speaker, but what are your thoughts on that? And what do people need to understand about the limitations on government, or what is the government allowed to do in these public spaces?
Yeah, definitely. Well, as usual, lawyers and courts have made it more complicated than it probably should be. A lot of these cases have multiple tests, multiple questions you kind of have to ask as you work through them. So one of the distinctions the Supreme Court has drawn is how do you define the forum? What kind of forum is this restriction happening in? Is it a public forum where people have traditionally had protests? So parks and sidewalks are a classic example of that. Is it a designated public forum where the government has sort of opened it up and said, we made this specifically for performances or protests? So that might be like a theater that the government opens, an amphitheater in a park. Or is it a limited forum or a non-public forum? So that varies, but that's basically, so for example, the DMV might be a case where it's government property, but it's never traditionally been, the home base for where you might do a protest. It's for a specific government function. And different tests, essentially when courts look at speech restrictions, they give more scrutiny or more skepticism for restrictions in public forums than in non-public forums. But even in non-public forums, the government still can't just do whatever it wants. There's still First Amendment rights, and the government still can't be arbitrary. So I would say that a house gallery, to some extent, you have to look at history. Going back, as long as the house gallery has existed, the first question might be, have people traditionally have silent protests? I think I agree with you. Probably a placard wouldn't be within that tradition. That would go against the function of what it's for, which is for people to watch the legislators. But if maybe for 50 years people had worn buttons, shirts, etc., that said messages and no one had stopped them, then potentially it's been established as at least a limited public forum to that extent, that there's a tradition of silent protests. And so then if it has been, courts would look more skeptically at the government suddenly cutting that avenue of expression off. And then the second thing you look at is what kind of restriction is the government making? So you look at the basis for how they're restricting it. Are they saying, so a viewpoint-based distinction is kind of the worst. So that's where you say, like, you can have a shirt that supports this bill, but you can't have a shirt that opposes this bill. That's almost always unconstitutional, even in non-public forums. So then the second level would be content-based distinction. So that's where you're not discriminating on viewpoint, but you're saying, for example, no shirts about any pending bill, but you can have a shirt saying, go USA, something political, but not specifically about pending bills, for example.
We the people.
So that
in
would
this
be,
specific case, the shirt said "We the people."
It's pretty hard to see how that would be controversial. So what we've seen. So a real world example is that there have been several cases about shirts in the polling places, and I've worked on some of those. My former employer, Pacific Legal Foundation, brought a case all the way to the Supreme Court and won it. I wasn't directly on that case, but I did work on some friend of the court briefs in my earlier stint at CATO, where I've come back to, that supported them. And basically, it's what the Supreme Court struck down this Minnesota law that said you can't wear any political shirt at the polling place. And even though that wasn't a public forum, the problem was that that's a content-based distinction and a very hard distinction to draw, exactly as we're seeing here. What counts as political? At the oral argument, Justice Alito grilled the lawyer for Minnesota and basically said, would a shirt with the First Amendment be political? And he said, no, that's just, American history. And then Justice Alito said, would a shirt with the Second Amendment be political? And the lawyer said, yes, that's a controversial issue. So literally it can vary by amendment whether it's political or not.
Yeah.
And it looks like, and the Supreme Court essentially struck it down saying that's too inconsistent. It's even if it's not viewpoint based, that's still a content-based distinction, and a pretty inconsistent content-based distinction, where different polling place judges, different, enforcers are going to make different judgment calls. And that's what I would look to here, that we may have the same problem, which is you can't literally, I don't think they're literally banning every shirt with words on it. They're not throwing people out with a shirt that says The Gap or Old Navy. Yeah. So once you have to read the shirt, you're in content-based distinction land. And courts are already going to be a little skeptical. And then it's basically, okay, where you're drawing the line. Is it something that's related to a bill? Is it something that's vaguely political? Whatever line you draw, it has to be something that can be applied consistently by every usher, each individual day. And that's what we may not have here.
Exactly. And then these volunteers are not necessarily trained in First Amendment law. And the court noted that there would be this expectation that if the standard was any relation to the activity before them, the legislative, all of the bills, hundreds of bills in this case, how could these volunteers possibly know every single word relation to pending legislation or active legislation? And so there's just no way that can be fairly applied or adjudicated at the doors.
Exactly. And in fact, it's strikingly similar to a case that's pending right now in the Fifth Circuit Court of Appeals coming out of Texas. So even after Minnesota's law was struck down, Texas retained a pretty similar law, but a district court judge nonetheless upheld part of that law. Part of that law said you can't wear anything in the polling place related to an item on the ballot. The district court judge said, well, that's all right. That's a more concrete rule than just anything political. But the problem is, this is another Pacific Legal Foundation case, same team that won this Minnesota case. They pointed out, you've got the same problem. What does related to mean? By any chain of causality, almost anything, you can connect it back to something that's on the ballot. In this particular Texas case, a woman was wearing a shirt that said, I'm a firefighter wife. And there was something on the ballot related to firefighter pay, even though her shirt didn't support or oppose it. It was a shirt she had for years before this even went on the ballot. And so again, you run into these same problems, which is, does anything with just a word related to something on the ballot trigger this rule and run afoul of the law or not? And different judges, again, were applying it differently.
So I have a question as well about the first point that you made when you talked about kind of what the established precedent had been in that space in the past. So say in the gallery, what had been allowed in the past. So my question for you is, I can't say for sure. Kim might have more of a recollection. I can't say for sure whether large groups of people have in the past come with stickers or shirts saying a specific thing to the gallery. I know they have in committee rooms and in other rooms, but I don't know. But I guess my question would be, if nobody had ever said that they were disallowed in the past, and certainly some people have, right? If you're talking a 50-year history, like you mentioned, certainly some people have. Can that then be said that is the precedent? That in the past it's never been banned or has never consistently banned. There may have been a time or two when something was said, but never in my recollection. So would that establish sufficient precedent as to the rules and behavior in that space?
It definitely can. As we know, sometimes there's a difference between the text of the rule on the book and what's actually applied. So, you can run into tricky difficulties if, say, there's some rule that's been there the whole time. You can't wear any sign, but no one ever applied it until suddenly they found it this year and they suddenly start applying it strictly. If you have that kind of situation, you've still essentially opened it up, at least as a limited public forum, effectively. And so I think courts do indeed look at what were people actually doing, not necessarily what did some rule, house rule that no one ever enforced before say. And that makes sense because the whole point of looking at what kind of forum is what worked in the past. What did people established it for? And so if this was an outlet for expression in the past, the government has to have a good reason if they're going to suddenly say this can't be an outlet for expression anymore.
Yeah, and we can't see a compelling government interest in having, the person who has a We the People shirt on or a sticker that says, vote for bill such and such. So this really seemed to be arbitrarily applied. And maybe coincidentally, maybe not, but the two separate incidences we had a couple days apart were on the same bill. Of hundreds and hundreds of bills, it seemed that all of a sudden for this bill, there was a new interpretation.
Yeah, no, it wasn't arbitrary. It was it seems absolutely intentional to me. Arbitrarily applied, the standard, yes, but they carefully selected when to make these rules. And I asked multiple people before this discussion tonight, have you been in any other meetings this year? Because we all end up in different committees that we're watching particular bills or whatever. Or have you been on the floor in the Senate or the House where these rules have been applied at any other time during this session? Nobody had that said when they were considering any other bill but this one bill where people want something different than what some members with a lot of power in the legislature
So it
want.
does seem like there was no content neutrality on this.
Yeah.
So, I mean, that just seems very, very apparent because, I've never seen the prohibition expressed or enforced or interpreted this way. So, Thomas, can you share with us really, our law specifically states a prohibition on signs or placards. And for really the first time I've ever seen this, the speaker interpreted a sign to also include any writing on your shirt. So where's the court really distinguished between the thing you might hold up and shake or something versus what you're wearing?
Yeah, so there are a few cases on that distinction. So prior to this Minnesota case, about 10, 15 years earlier, there was a case called Burson versus Freeman, where the court upheld a limitation on speech around a polling place. But there they really focused on active campaigning. So there the statute said you can't go up to someone and tell them vote a certain way, and you can't have campaign materials that you're handing out or that you're kind of pressing upon people. So that's sort of more analogous to the placards that you're talking about. And the government has a higher sort of interest in regulating those, both because it can be, blocking a view. It can also the notion is that it's more likely to sort of cause interpersonal conflict if you're coming up and sort of pushing something on someone else rather than just wearing something on your clothes and not engaging with anyone else in any way. So on the flip side, there's a very famous First Amendment case called Cohen versus California, where a person was opposing the draft, went into a courtroom with a bad four-letter word followed by the draft on his jacket, didn't engage with anyone, didn't have a placard, was arrested, and the Supreme Court said, no, he's got a First Amendment to wear that despite the bad word on it, because it's essentially, there was no conflict, there was no disruption caused by it. You can't just assume that a naughty word or a political view on a shirt is going to cause a fist fight just by people seeing it. And so I think that's pretty analogous to what we have here. We have a pretty clear standard and an expectation that nothing more than a message on clothes that's not blocking anyone, that you're not putting in anyone's face, that's not enough. That doesn't create a presumption that you're going to cause a disorder or disruption or a fight. And so you have to have a pretty high justification explaining what's wrong with people passively displaying this message. And even the justification in the polling place cases, it seems to me doesn't apply there, because the other justification is people need to kind of have a clear mind when they go to vote. We don't want to sort of have last minute influences. We want to give people some time for contemplation. But is the notion that here, like, the legislators also need a clear mind, that we can't, that legislators are so impressionable that we can't have them see a shirt up in the galley because it could change their vote at the last minute? I mean, that's honestly the only justification I can see for why a passive message would be a problem. And I don't think any court would buy that.
And I think, too, Carolyn's former point that this particular bill seemed to flood the gallery with that particular message, it should not be a consideration of what percentage of the people are expressing the pro or the con. If every last person had that expression, that's their right.
Yeah.
And so, did we have leadership that didn't like that expression, felt intimidated by the outpouring of that side of expression? But it should not have been just arbitrarily applied at that moment because there was that much of the percentage of people there.
Yeah, it seems to me that if they wanted to get away with it, they should have started applying this rule sooner in the session so that it wasn't so obvious.
Right. So
what
now,
was probably going down.
It's absolutely, arbitrarily applied. It's not content neutral. Right. So Thomas, we still don't know what exactly happened in the committee meeting, and I would concede that the four are a little bit different in that one's a gallery for observation, though you have historically been allowed to wear expressions of speech. The other was an active public committee hearing where the public is allowed to approach the microphone, speak to the committee. I would think that there should be even more allowance and erring on the side of the expression of that committee, because that is a room where speech is actively expressed, at least verbally.
Right. Yeah, absolutely. And obviously you can have regulations on what people speaking one at a time, the so-called time, place, and manner restrictions. You can say you can't bring a bullhorn and, shout down the person at the mic at any given time. But exactly, if the purpose of that meeting room is to try to persuade or to influence members of a committee, you have even less of a justification for banning, persuasive apparel.
Now, we don't know, and like we said at the top of the show, we really don't know exactly what happened, and not all the iPhone videos are all out yet. But do you have advice for someone who is in that situation? I mean, clearly it escalated to some degree that someone was handcuffed and dragged out. What would you advise to someone who finds themselves in a situation where they believe that they have the right to express themselves, and what do you do? Because you don't want to.
And let me say one thing as we finish up. So the individual believed that they had the right to express themselves, and when approached by Highway Patrol, did not comply with the instructions that were given to them. So there is, it's a difficult situation, right? Because they likely were in the right. But they were in this situation right then when compliance may have alleviated the pressure, and that could have been dealt with later.
Well, but compliance meant leave.
Correct.
Leave, because you have a shirt that's offensive to
or a
room.
sticker.
Or a sticker.
Yeah. So, as we finish up, would you just kind of give us your take on Kim's question? Like, how should an individual handle that type of a situation?
Sure. It's a tricky situation, and there's no perfect answer. If you think you have your First Amendment right is being violated, but nonetheless it's being enforced against you, and you're being asked to comply, by threat of force. I think what I would say is that it's a difficult question in the moment, but in the long term, the good thing about the rule of law is that you can have court cases that adjudicate these, and it's not perfect because you can't ever get that moment back necessarily if you were kicked out. But as we saw in this Minnesota polling place, and as we're seeing in this Texas polling place case, it can eventually lead to cases that set precedents that prevent this from happening in the future. And that can be the silver lining of these conflicts. If you have someone who's, really upset about the fact that this happened and wants to make it not happen in the future, you can bring a lawsuit, you can set a precedent. Maybe the government will change its policy spontaneously once you draw more attention to it, or if not, you can get a court ruling that establishes it even more concretely. And that's what we, if someone hadn't sued, pressed their rights and drawn attention to the fact that they were kicked out of these Minnesota polling places, we wouldn't have had the Supreme Court a few years later set this precedent that no, you do have the right to go in and not have, a law arbitrarily applied against you, that polling place judges can't even, apply consistently case to case.
Yeah. Yeah. So thank you. I think that was really helpful. And I think that there are a lot of politically active people in Utah who are waiting with bated breath to see this interview, actually.
Absolutely. And we've also had legislation, just to kind of give a broader context, of our school board meetings where parents have been barred, they've been excused, and they're not allowed to come in a venue that has historically been very open for that expression. So we have some challenges on these free speech and public venues in our state right now, Thomas. And so, thank you so much for the work that you're doing. Where can people follow you and the work that you do with CATO and your other projects?
Sure. Oh, sure. So I have a site. I have a page at the CATO website. So you can just search Thomas Berry at the CATO website or go to cato.org/people/Thomas-Berry, and you'll see all the op-eds and friend of the court briefs that I do there. I focus on a few major topics. First Amendment is definitely one of them. Government separation of powers is another at the federal level, especially rules of appointments and other government organization things. And you can follow me on Twitter as well at Thomas_A_Berry, where I generally post links to similar work, but also comment, more short form on breaking legal news.
Great.
Awesome.
And I'm so excited that your other issue, I think we both are, right, is
Separation
issues of
powers.
separation of
That's
powers.
like our hobby topic.
We are friends with Senator Mike Lee, and I just left his employs. So you've probably worked with him on a few things.
But certainly aligned on many of those issues. Absolutely.
Yeah.
Well, thank you so
Thank
much
you.
again for your time and all the work that you do in this area.
Thank you very much for having me.
You bet.
Thanks. Bye-bye.
All right. Well,
Yeah. This is, the session is ending with a bang. I think that there are a lot of emotions that have been stirred up, and I think that people have, through probably the first 2/3 or probably 3/4 of the session, felt like at least their voice was being heard. And I think that the people speaking out, and by the people, actually, I mean individuals who have not traditionally been that actively involved, has started to wear on our lawmakers. And I think it's starting to impact behavior.
well, there is this world of people that don't believe their voices are being heard.
Yeah.
And one of the things I try to convince citizens all the time is lawmakers do hear you. The good lawmakers, they really do. They want to hear from you. So to end the session with a real act of suppression of speech is not helpful for anyone. It's a bad look on the legislature. Yeah. It just adds to the frustration of people feeling like the government isn't listening to them.
Yes.
And that has been a heightened sense in the last 2 years. But to now actually have suppression of speech that is
in our state,
that is likely unconstitutional, and we heard from one of the foremost experts on free speech in public fora, and the legislature misstepped in a couple of different places here, and I'm curious to see what's going to happen. I mean, there are pending charges against the person who, committed the heinous crime of, we don't know what he did, so I don't want to, but he was, because he wore We the People.
Of not leaving the room. We know that, of not leaving the room.
Because, let's be clear, because he had We the People on his shirt, and he had a pro Ep.60, which is the vaccine mandate prohibition bill. He was asked to leave the room, so we've, Fosmu has a question.
Yes, so what is the status of HB60 at this point?
Unless it was voted on today, I was so busy with some things today, I actually don't know, but it passed through the Senate committee, and I don't think it's passed the Senate yet, but it could have. There were a lot of them. There was a big amendment made to it, and so in committee, and it will need to go back to the House anyway.
So, one of the most important issues of the session, is your health status, privacy, and whether you can be forced to a vaccine. And both times this bill showed up, once on the floor, once of the House, and then in a Senate committee, actual expression, freedom of expression was suppressed by the two people leading those committees. And at least for one, that was very... a little bit uncharacteristic to me. So I do want to reserve judgment on really what happened there. But we do know people were asked to chill, remove, and suppress their expressions that are constitutionally protected, even more so in these venues.
And I was told that stickers, I wasn't there that day, but I was told that stickers were not allowed in the room, but that pins would have been.
Because there's an incredible distinction between an expression that you stick to your shirt versus pin to your shirt.
Yes.
Very big difference.
Apparently,
very big difference.
I haven't figured out what it is, except for the method of application.
No, absolutely. These are people that whoever told you that is really up in the night and grasping.
It was a decision
for
maker.
anything.
It was a decision maker. But I will say this too, that I feel like members of the public, there has been uncharacteristically large involvement this year because people are realizing, that their freedoms really are being impinged upon, and they are seeking the redress of lawmakers.
So, and I don't know that this is all that unusual. I mean, because I think it's very similar to back in 2009 in the era of kind of the Tea Party era, as it was called back then.
Were people attending meetings?
People were standing room only out in hallways. We've had specific issues over time absolutely. They will stack the gallery. They'll stack committee meetings out the hallways in overflow rooms. And so this is not that unusual of a year, but the dynamic is different.
Yes.
The dynamic seems to me that there is a little bit more resistance on the policymaker sides. They want the public to go away.
I'm feeling that.
And then some of the on the citizen side, they're done. They are tired of being silenced and tired of being ignored. And so I don't know that the numbers of people or the level of activity has changed so much as the dynamic is just a little bit more sensitive, a little bit more heightened.
Yeah.
This was not the year to tell people to stop their expressions.
That's correct. But I will say this too. And I've been in a whole lot of meetings with people on the other side of the aisle with lots of displays that have not been treated the same way.
Absolutely.
But I wanted to say, I feel like with these large numbers of people have been overall respectful and able to engage productively. Yes. I think we all get concerned when anybody, no matter what their political views are, kind of jumps to conclusions or behaves inappropriately, yells, screams, throws temper tantrums, or even, we see this on both sides, and I can't stand whenever I see it even on my own side, and that is making assumptions without ever talking to somebody and assuming that they're out to get you when sometimes they may just be doing what they have to do to get the bill to pass or whatever, because without those changes, you would have nothing, so better a little bit than nothing. But I think that we've done a pretty good, that most people really have done a good job of that this year. And so I feel like for this type of pushback from the legislature and resistance, they are creating something that they don't want to create, right? People have been fairly, and I don't know all the emails they're getting or whatever, but everything that I've seen, people have been fairly measured. Mm-hmm. People have been respectful. And in these meetings where the last one, where it was on the House floor, where they had their stickers, it was a bunch of quiet, respectful people sitting there with their stickers. So I do think that if you want to push people, this is the way to do it. and I don't think that it helps to solve the problem that they're trying to solve.
No, it really was not the year. And, but yeah, that's the dynamic.
Yeah.
The lawmakers, I mean, and when you look at, I mentioned the school boards throwing people out, shutting doors, getting rid of public comment period, things like that, which we had bills that address that this year. Unfortunate. So, you know, let's mention that tomorrow, Friday, because this will probably come out on Friday.
Yes.
So Friday, by the end of the day, Friday, 5 o'clock is the deadline to file to run for office. And it's a real good time for lawmakers to reflect. If, if they're up for this again.
Yes.
If you're someone that maybe doesn't want to deal with public outcry and public pressure, then maybe this is not the job for you.
Yeah,
and maybe
might not
let
be.
somebody else do it. But definitely. So anyway, it was great to have Thomas on.
Yes, I think that was really helpful for us and for a lot of other people who've told me that they're very interested in this issue and what the reality is as far as the SCOTUS rulings and how this ought to be dealt with.
Absolutely. And I think the bottom line of all of this and the court cases that Thomas mentioned is the courts err on the side of freedom of speech. And it is one of the most American things. There are very, very few aspects of speech that are not protected. Mm-hmm. When you can wear an F the draft into a courtroom and that is protected. Yeah. And there are very, very few examples of where speech isn't protected. But that gallery and that committee room, that was protected.
Yeah. I think we can easily and safely say the committee room and the gallery. In your time serving in the legislature, did you ever once hear that type of an announcement?
No. Well, because the law doesn't say it. The law says signs and placards and stickers and pins or, silk screen on your shirt
are not the same
has
thing.
never been interpreted that. Yeah. And what's interesting was, Speaker Wilson just said in his comments that I have just sent the green coats, that's the name for the lovable name for these volunteers. I've sent them up to go enforce this now today. So a lot of problems with that. And
Highway Patrol was told to enforce it as well.
Yeah.
I was there.
So there needs to be, the legislature needs a little bit more training on First Amendment.
Yeah, I think that's the conclusion we can come to.
And while they're at it, separation of powers. While they're at it, medical privacy. There's a whole lot of things the legislature needs.
A lot of them we can have a discussion about.
Be reminded about.
Yeah. Anyway. Well, I'm really glad that we had that opportunity and want to thank all of you for joining us tonight. Please listen to us on anywhere you find your podcast, Straight Talk with Kim and Carolyn. You can also find us on YouTube and on Facebook. Like us, follow us, share us. And Rumble. Yes, I was just on Rumble today. FOSMU. We always have to thank FOSMU. Thank you, FOSMU.
My pleasure.
And if anybody can figure out how Truth Social, if it's ever going to really, maybe we'll be there.
Okay, we'll see what we can do with that. But yeah, there's actually an attorney I listen to, and he just got kicked off of YouTube for a week again, so I had to catch him on Rumble today. So anyway, thanks for joining us. See you next time.